Welcome to the West Virginia Legislature on the West Virginia Channel. I'm Beth Voorhees. Here's a look live into the House of Delegates chamber as we await a public hearing on Senate Bill 267, modifying removal procedure for certain county, school district, and municipal officers. This bill is sponsored by Senator Craig Blair and passed the Senate 32-1 on February 17th. The bill has been before the House Committee on Government Organization since February 18th. Following this public hearing, there is another public hearing at 9 o'clock on Senate Bill 6, requiring drug screening and testing of applicants for Temporary Assistance to Needy Families program, requiring drug testing of applicants for whom there is a reasonable suspicion of substance abuse. The sponsors of Senate Bill 6 are Senators Ferns, Carmichael, Gaunch, Kubo, Trump, Prezioso, Stallings, Plymel, Blair, Carnes, and Seipold. That bill passed the Senate 32-2 on February 9th. The bill passed out of the House Health and Human Resources Committee on February 10th, and the bill has been before the House Judiciary Committee since February 12th. That's on the drug testing bill, Senate Bill 6. But the matter at hand this morning is Senate Bill 267, modifying removal procedure for certain county, school district, and municipal officers. We'll join the public hearing as soon as it begins.
All right, thanks for coming out this morning. If you haven't signed up to speak, please do. And to the mass of people here, try not to disrupt the speakers. And they'll bring the sheets up and we'll tell who's first here. Yeah, first up is Jack Woodrum.
5 minutes each. 5 minutes each.
Yeah, 5 minutes each. To limit you to.
Be careful not to go over.
Yeah, be careful not to go over because we just don't want to be here late into the evening.
Mr. Chairman, honorable members, I'm Summers County Commissioner Jack David Woodrum, and I stand before you today as Chairman of the County Commissioners Association and a member of the West Virginia Association of County Legislative Committee. We are here in support of SB 267, modifying the removal procedures for certain county, school district, and municipal officials. The bill raises the threshold of the number of signatures needed to begin the removal process to the lesser of 2,000 or 10% of the number of registered voters in the election in which the challenged officer was chosen. Current law, states at 50 or 1% of the total number of voters who participated in the last election. This bill clarifies the currently loosely defined procedures for removing an elected official from office. adding definitions for both misconduct and qualified petitioner that are not currently in the legislation. Currently, anyone wishing to remove an elected official from office can collect petition signatures on a blank sheet of paper. This bill outlines a much more common sense process in which the signatures must be collected on a document that outlines the alleged charges against an official on each page of the petition. This bill also outlines a process in which the charges must be first be vetted at a preliminary hearing before the circuit judge in the county for validity before moving on to trial. This process will save counties and municipalities a great deal of needless expense. They currently must take each complaint, regardless of its legal validity, into litigation, and this drives up insurance premiums and is ultimately a cost borne by the taxpayer. We request your support in passage of SB 267. Thank you.
Thank you, sir. Patty Hamilton.
Good morning, and thank you, Mr. Chairman. I could probably just use my old school teacher voice for this crowd, but I'm Patty Hamilton, Executive Director of the West Virginia Association of Counties. 1% or 50 registered voters, whichever is less, is the current law. You wouldn't have to go much further than your own neighborhood to get enough signatures for a serious petition for removal. Currently, people can sign a petition that is a blank piece of paper, no name or any reason for removal stated. This starts a process that can cost, at minimum, $10,000 of public funds. Senate Bill 267 raises the threshold, but keeps it at a reasonable level. It's easy to reach, but not so easy as to be initiated frivolously. A petition of 50 signatures or less can set into motion an expensive, arduous process. We think a higher standard should be set that keeps the ability to initiate a removal and makes it clear what people are signing. A frivolous petition is a frivolous use of taxpayer funds. We ask you to support Senate Bill 267. Thank you.
Lisa Dooley.
Thank you, Mr. Chairman, members of the committee, all four of you. I could call each one of you by name. I really don't need to add much to what Ms. Hamilton and the commissioner said. The league is in support of 267. But I will tell you a little story since we have a little time. You guys have changed on this side of the house. I mean, there are a lot of new faces over here, and so I was over here working this bill with Howard Mullins, our lobbyist, and we were just talking to everyone, and I talked to a delegate, and I told him about the issue, the frivolous lawsuits, and he said, "Oh, I'm with you, honey. We like this bill." And after he left, I turned to Howard and I said, "Howard, who was that?" And he said, "Honey, that was the doorkeeper, but he's for you." So anyway, our desire is to keep the frivolous lawsuits out of the court. Again, as Ms. Hamilton said, clarifying the process. Our actions weren't determined or spurned on by cities, any one particular city. The County Association, the West Virginia County Commissioners Association, and the Municipal League worked on this for 2 or 3 years trying to clarify the language, because what we've seen are petitions coming up from everywhere, just from folks who are aggravated with their government. And while we don't want to take the removal process away, we're seeing a problem that we need to address in clarifying the statute, clarifying the guidelines for the court, and making it just a little, raising the bar just a little from 25 signatures for municipalities to at least 10% of the registered voters. And we do that, again, not to stop the removal process, but as you think about it, these are elections that we're overturning. 25 people could overturn an election that 40,000 people participated in, really not preserving the right or the will of the people. So our need is not to make this process overly burdensome, But there are clear guidelines that need to be established, especially when you're doing something as drastic as overturning an election. There are already processes set in the code that will take care of the gross misconduct, all of the things that, you know, we'd want someone removed from office for. Those are set in place. But these petitions, as I said, are being used just because folks are getting aggravated at when the cities take legislative action. So we're not opposed to having that ability for removal of office for an elected official, but we want clear guidelines established to overturn an election that reflects the will of the people and protects the rights of all. Thank you, Mr. Chairman.
Thank you. Vivian Parsons.
Mr. Chairman and distinguished members of the committee, good morning. Thank you for the opportunity to speak on this issue. As the chairman said, my name is Vivian Parsons, and I represent county commissioners from across the state. I'm the director for the County Commissioners Association of West Virginia. My members fully support passage of Senate Bill 267, modifying the removal process for county, school district, and municipal officers. Right now, as you've heard before, but some of you have just come in, 50 signatures on a blank sheet of paper constitutes a legal petition to start the removal process of an elected official, 25 in a municipality. We feel this bill will improve a process in current statute that is somewhat vague and indifferent to the varying populations and sizes of counties and municipalities. We feel that the current statute, as I said, requires only 50 signatures on a petition to begin the removal process, and this is a very low threshold, especially in larger jurisdictions. I'll give you an example of our largest county, where there are over 136,000 registered voters, down to our smallest county, where there are 4,500 registered voters. And so the situations are treated exactly the same across the board. This bill would treat different sizes of counties and municipalities more fairly by requiring the lesser of 2,000 or 10% of the number of registered voters in the election in which the challenged officer was chosen to sign a petition for removal. This bill would also create a common sense process in which petition signatures must be collected on a document that outlines the alleged charges against an official on each page of the petition. That would seem like a given, but in fact we had a case most recently where signatures were on blank sheets of paper and they had to be considered. Currently, anyone wishing to remove an official from office can collect signatures on blank sheets of paper, leaving one to wonder if in fact someone understood what they were signing and what the allegations truly were. Finally, the bill outlines an intermediate step in the process in which the alleged charges must first be vetted at a preliminary hearing before the circuit judge in the county for validity before moving on to trial before a 3-judge panel. This step will save needless legal expense when allegations do not rise to removal level. And as you heard from Ms. Dooley, what we are seeing this used in most cases is not for an egregious act. We don't want to change the benchmarks that are currently in statute for removing someone from office, like gross misconduct or malfeasance. But these are coming about because, like you, our local bodies, county commissions and municipalities, are legislative bodies deliberating toward hard decisions. And you please some people, you displease others. And this process that was put into place to remove someone from office for a very egregious act is now being used because we don't like the fact that an ambulance fee was put into place, although the statute allows a county commission to do that, or a fire fee, or a hiring of someone they don't like. With this new step in the process, a circuit judge could review and determine whether or not this is an issue or an allegation that actually arises to the level of removal from office. And this step would save needless legal expense for the counties. These are taxpayer dollars. Currently, each petition complaint must go directly to a 3-judge panel regardless of the validity, resulting in costly litigation. And this drives up insurance premiums, ultimately, again, cost to the taxpayer. This bill does not change the reasons an elected official can be removed from office. It simply improves the vague process treats different-sized jurisdictions more fairly based on the number of registered voters, creates a preliminary hearing before the circuit judge to determine validity of charges, and if allegations are determined to be valid for removal, moves forward with the current 3-judge panel process. Thank you. We ask for your support on passing this legislation.
Thank you. Anyone else wishing to speak? If you have any materials you'd like to give staff, please drop that off here or at the committee room. Thank you all for coming. Please exit the room in an orderly fashion for your own safety.
A very brief public hearing on Senate Bill 267, modifying removal procedure for certain county, school district, and municipal officers, representatives, all backing this bill as it changes the procedure for trying to remove an elected official from office. A very short public hearing. We have another one coming up at 9 o'clock. Until then, we're going to take you to our regularly scheduled programming. We'll be back at 9 for another public hearing on Senate Bill 6, requiring drug screening and testing of applicants for TANF benefits. Until then, I'm Beth Voorhees for the West Virginia Channel, a service of West Virginia Public Broadcasting.